Morning, everyone, and welcome to this special meeting of the Standing Committee on Justice and Human Rights. On est ici pour étudier la nomination de...
We're here to study the appointment of the Honourable Nicholas Kassirer to the Supreme Court of Canada. This is the third time that we are going through this process.
For Justice Rowe and for Justice Martin when they were nominated. And it is a pleasure to be joined today by the Honourable David Lametti, the Minister of Justice and Attorney General for Canada, and the Right Honourable Kim Campbell, our former Prime Minister et Président du Comité consultatif indépendant,
and Chair of the Independent Advisory Board concerning the appointment of Supreme Court of Canada justices.
We're going to be joining the Senate's Constitutional Legal Affairs Committee and parliamentarians from non-recognized parties to question the nominee. And before that, this morning, we had the opportunity to hear from Minister Lametti and former Prime Minister Campbell about the process that led to the nomination of Judge Kassirer and to ask them questions about it. So I will turn the floor over to the Minister of Justice and Attorney General, David Lametti. The floor is yours.
Merci, Monsieur le Président. Ce que je vais...
Thank you, Chair. First, I will be giving a preliminary address, and then I will give the floor to the Right Honourable Kim Campbell. Then I will take the floor again, and then both of us will be happy to answer your questions. So, Mr. Chair, Right Honourable Kim Campbell, members of the committee, and other parliamentarians, and ladies and gentlemen, I know that there are many people here today, including the Honourable Irwin Cotler. Thank you all for being here. First of all, I'd like to recognize that we are on the traditional lands and traditional unceded territory of the Algonquin people. I think it's very important to mention that today. I'd like to thank the Chair for having convened this special meeting of the committee, and I'd like to thank all members for their presence here today. Of course, I recognize that many of you had to rearrange your summer plans in order to be with us, and I'm very appreciative of that. As the Chair just mentioned, this is the third time that our government has gone through the reformed Supreme Court appointment process.
Introduced in 2016 are designed to ensure greater openness, transparency, and accountability in the appointments process. Many of you here today are seasoned participants, having been part of the 2016 and 2017 processes that resulted in the appointments, respectively, of Justices Rowe and Martin. And Madame Campbell, above all, was the chair of those committees as well. Comme vous pouvez l'imaginer, j'ai suivi le déroulement.
As you can imagine, I followed those processes with great interest and attention. Now, it's a great honor and privilege for me to be able to participate more directly in the process to help fill the spot that will become vacant on September 15th, 2019, when Justice Clément Gascon retires. I'd like to take this opportunity to thank once again Justice Gascon for his contribution, and I would like to underline the courage that he has shown throughout his career.
I have the pleasure of appearing today with the Right Honourable Kim Campbell, who joins us via video conference from Vancouver today. Ms. Campbell has previously served as the chairperson of the Independent Advisory Board for the Supreme Court of Canada Judicial Appointments. Ms. Campbell also served as the chairperson of the current advisory board that was adapted to ensure the appointment of a judge properly grounded in the legal experience of Quebec and its legal tradition. Ms. Campbell's extensive experience with the selection process has been an invaluable resource in this process. We are grateful for her continued dedication to serving Canadians in this role. Thank you. In a few moments, I will turn things over to Ms. Campbell to describe the specific work the Advisory Board undertook in order to produce the short list of candidates for the Prime Minister's consideration. Before doing so, however, I would like to briefly outline the unique aspects of the current process to fill this Quebec seat on the court. Selon la loi sur la Cour suprême, 3 sièges de la Cour sont réservés.
According to the Supreme Court of Canada Act, 3 seats on the court are reserved for judges from Quebec. Under sections 5 and 6 of the Act, it is only possible to appoint people who are Quebec Court of Appeal judges or Superior Court of Quebec judges, or people who have been in good standing, members in good standing of the Quebec Bar for at least 10 years. As the Supreme Court of Canada stated in the reference regarding the Supreme Court Act, sections 5 and 6, these nomination criteria aim to ensure that Quebec's distinct legal traditions are properly represented on the court. These criteria not only ensure that the court is able to deal with civil law cases appropriately, but also ensure that it is seen as legitimate by the Quebec people. That is why the evaluation criteria and qualifications state that in-depth knowledge of the civil law tradition is essential for any candidate for one of the 3 positions from Quebec. Furthermore, on May 15th, 2019, the Prime Minister announced a memorandum of understanding between our government and the province of Quebec. This memorandum of understanding establishes the path to follow in order to fill this position, which will become vacant when Justice Gascon retires. As with the process that applies to seats that are not Quebec seats, this is based first and foremost on the work of the Independent and Impartial Advisory Board, which is charged with evaluating the candidates and drawing up a short list of 3 to 5 names to recommend to the Prime Minister. The composition of the advisory board has been adjusted in order to more faithfully reflect the reality of Quebec, as well as its legal practices and its civil law tradition. As I mentioned, the advisory board was chaired by Ms. Campbell and included one other member that I am charged with appointing in my capacity as Federal Justice Minister. The 6 other members were selected in order to ensure that there was adequate representation of Quebec and of the civil law tradition. Those 6 other members were designated by the Minister of Justice of Quebec, the Quebec Bar, the Quebec Division of the Canadian Bar Association, the Canadian Judicial Council, and deans of various Quebec law faculties and the civil law section of the law faculty of the University of Ottawa.
All of whom are functionally bilingual, represented a distinguished set of individuals who undertook their important responsibilities with great care and dedication. I would like to thank them on behalf of the Prime Minister and our government for their exceptional service throughout this process. They did a better job than those working the lights today. The core mandate of the advisory board was to assess candidates against the published assessment criteria and to submit to the Prime Minister the names of 3 to 5 qualified and functionally bilingual candidates. Conformément à l'entente conclue.
In accordance with the agreement signed with the Quebec government, after having received the shortlist from the advisory board, I gave it to the Minister of Justice of Quebec. Then, we each led confidential consultations concerning the pre-selected candidates. My consultations included the Chief Justice of Canada, as well as a certain number of my cabinet colleagues, opposition justice critics, and members of your committee and of the Standing Senate Committee on Legal and Constitutional Affairs. Quebec's Justice Minister led his own consultations as well, notably with the Chief Justice of Quebec, before sharing the results with the Quebec Premier. After that consultation period ended, the Premier of Quebec and myself submitted our respective recommendations to the Prime Minister of Canada in order to help him choose the person to be appointed.
Before turning the floor to Ms. Campbell, I would like to speak briefly about the importance of confidentiality in this process, given the concerns that have rightly been raised about improper disclosures surrounding the 2017 selection process. As I have said previously, the disclosure of confidential information regarding candidates for judicial appointments is unacceptable, and I want to stress that I took strict measures to ensure that confidentiality was respected. This process has implemented strict confidentiality measures throughout. The terms of reference for the advisory board contain provisions specifically designed to ensure that the privacy interests of all candidates are respected. This includes a requirement that advisory board members sign a confidentiality agreement prior to their appointment. In addition, the agreement with Quebec explicitly states that the sharing of and consultations on the shortlist are to be conducted in a confidential manner. In terms of next steps in the process, in addition to the advisory board's critical contribution in developing the shortlist, today's hearing is another important element. It provides an opportunity for all of you as parliamentarians to hear from and question the government regarding the selection process and our choice of nominee. And parliamentarians, and Canadians more broadly, will have the opportunity to become acquainted with the nominee himself through the question and answer session that has been scheduled for this afternoon. Having provided this context, I would now look to Ms. Campbell to describe the work of the advisory board, the work that the advisory board undertook in fulfilling its mandate. I will then say a few words about the Prime Minister's nominee to the Supreme Court of Canada, the Honourable Nicholas Kasirer. Madam Campbell.
Mille merci. I want to say good afternoon, first of all. I mean, this is old home week in a sense for me and this committee. This is the third time we've had the opportunity to discuss this very important process. And I do regret that I'm not there personally to give you all a valedictory handshake and perhaps a hug, since I'm sure this will be the last meeting during this mandate. But I do want to say how much I've appreciated the opportunity to speak with you and hear your points of view on the work of the committee. And so to the chair, Mr. Anthony Housefather, vice chairs, the Honourable Lisa Raitt and Ms. Tracy Ramsey, and members of the committee, it is my pleasure to be before you. And it was my honor to chair the committee. I might say that the difference between the work of this committee and the two others is that on a travaillé presque partout, presque toujours.
We worked almost entirely in French. Now, that may surprise you by listening to my French, but, you know, I am from Vancouver. But nonetheless, it was very important for us to reflect the reality that we were choosing candidates from the province of Quebec.
So we did, and I will speak more French, except that I'm very tired since I just arrived yesterday from Africa, and I don't really want to massacre la langue de Molière.
To massacre the language of Molière.
But we did, in fact, do most of our work in French, and that was the difference from the other exercises. I also want to say, as I've said to you before about the other two iterations, how every time somebody says to me, oh, thank you for your good work as a chair, the members of the committee made my work quite easy. And I think you would be very proud and happy to know with what incredible professionalism and dedication to serving Canadians across the country, not just Canadians in Quebec, the members brought to their work. My goal has always been in these exercises to ensure that each member of the committee has an opportunity to speak freely for himself or herself, so that we get a genuine exchange of ideas and we avoid groupthink and any other dynamics that can undermine the quality of decisions. But I must say this was an outstanding group of Canadians who really took their responsibility very seriously. And I was, as I said, it made my job easy, and I was very proud to serve with them, and I can say nothing but the finest things about them in terms of their competence and their character. And incidentally, as I've seen in the other two examples, often the two members of the committee who are not lawyers also bring a very important dimension and a very clear understanding of what the court means to the legal life of our country. So I admire them very much. The 2019 process was opened in April 18th to fill the seat, and candidates were required to submit their applications by midnight Pacific time, Friday, May the 17th. So that was a period of 4 weeks. And I think we'll come back and discuss this a little bit about one of the challenges that we face is the timing of this. Of the three examples or three iterations of this committee's work, 2 were done to replace judges who took early retirement. For replacing the Chief Justice, we had more time because her retirement was anticipated. She retired close to her retirement age. But I think one of the challenges, and I want to come back and make some suggestions about this, is that when justices of the Supreme Court of Canada take early retirement, this changes the time frame in which sometimes it's most convenient or appropriate to engage in the search process, particularly if we want to ensure that the court is up to full complement at the beginning of a new season of its work. The remaining advisory board members were only announced on May the 15th, but as soon as the process was launched, I began, and I was confirmed to be the new chair, I set about making contact with all of the organizations that we've contacted in the past iterations to ask them to communicate with their members about the new opening and to encourage them to consider whether they would like to be considered as candidates for the new seat on the court. So I didn't wait for the other committee members to be appointed, but began right away in communicating. And again, I have some other comments I'd like to make about that process. You know, of course, I'm not going to repeat the requirements of the Supreme Court Act to have 3 civil law trained judges from Quebec. And the quality of candidates was really outstanding. There were 12 candidates, which was perhaps about right for, we had 14 candidates, I think 12 or 14 candidates for the Western seat. The first seat that we considered had many more candidates because that was originally meant to be, or that was, it was a national competition. I will say that only one of the candidates was a woman, and again, that is something that the committee members were disappointed about. There were no Indigenous applicants in this process. So I think we want to talk about how we can encourage a broader range of Canadians to apply. And I will give you some of my reflections on why we have encountered those issues. The board members, first of all, convened by teleconference. We then met in Ottawa between May 27th and June 7th to discuss our evaluations and to proceed with our methodology of identifying and looking at candidates individually before we came together, again, to avoid groupthink, to avoid too much influence before each of us had had the opportunity independently to review. But before that, we came on May 21st to meet with the Chief Justice. And as you know, it's been our tradition to meet with the Chief Justice before setting out on our business. This was our first opportunity, obviously, to meet with the new Chief Justice, Wagner. And as in the other 2 cases, we found that our meeting with the Chief Justice really helped to set us up for our work in reminding us of the reality of life on the Supreme Court of Canada, what is required, and what are some of the things that we should be looking for as we interact with our candidates. And I think what was interesting for us in talking to Chief Justice Wagner, and those are confidential conversations, but same thing, I don't think that he hasn't said to Canadians more broadly, but he, as with the other meetings we'd had with Chief Justice McLaughlin, there was an emphasis on the importance of collegiality. And again, one wants justices who have strong views, who are capable of expressing themselves, but collegiality on the Supreme Court of Canada is not groupthink. It is the ability to try as much as possible to create clarity in judgments that become the architecture of Canadian law and are so important for lower courts and practitioners. So this ability to work towards the clearest possible elaboration of the court's views on issues is a very important part of the temperament of a constructive Supreme Court justice. But the other thing that was very interesting was when Chief Justice Wagner talked to us about the uniqueness of the Supreme Court of Canada as both bilingual and juridical. Now, we knew that, of course, our judges, one of the requirements of our candidates has been to be functionally bilingual. And of course, that the Supreme Court Act requires that there be 3 civil law trained judges on the court from Quebec, although Justice Martin is also a civil law trained judge, so the strength of civil law capacity on the court is certainly well established. But he made the very interesting comment about how unique this makes our Supreme Court, and how, in terms of the way other courts around the world look at our judgments, that we have a very special set of competences among our justices. And I know certainly that many common law judges enjoy the opportunity to study the civil law because it's a different route often to getting to the same answer. So that really put our work in a different context, in the sense that we weren't just looking to fulfill the requirements of the Supreme Court Act, but that we were working on an exercise that helps to define our court more broadly in the world as uniquely, extremely broad in its juridical competence. And I think we felt quite inspired by that notion. And of course, the candidates that we interviewed were quite outstanding in that regard. So after meeting with the Chief Justice and doing our work, we presented our shortlist to the Prime Minister. I'm very happy to answer your questions. So I would just like to conclude with this comment. I noticed that there have been 9 nominations since 2011, including Justice Casserer, to the Supreme Court. And I remember the first meeting we had with Chief Justice McLaughlin. She felt that the ability to commit, say, 10 years to the work on the court was, highly valuable for a Supreme Court justice, simply because it takes time to ramp up, to get up and running, to find your feet, but also that continuity and lack of disruption are very important. But clearly, there are reasons for judges not necessarily to serve their full time on the court. And I think both in terms of getting the quickest response from strong candidates to the opportunity to be considered as a candidate for the court when retirements come, or when early retirements come, that we've talked about a process, and I would be very interested in the members of the committee, their views on how this might be approached, as a way of starting a conversation, an ongoing conversation, with members of the Canadian judiciaries in all of the provinces and senior members of the profession about what it means to serve on the Supreme Court of Canada. What are some of the nuances? What are some of the requirements? Because it's a very difficult job. It isn't just that one has to be an outstanding legal thinker, but one has to move to the National Capital Region, one has to move to Ottawa, and often at a stage in life when a spouse's career may be at its most active and prominent stage of development, when family obligations make it difficult. So I think by having a broader conversation with people in the profession about what is required to be on the court, so that there's greater knowledge of what it actually means, I think that might, first of all, enable us to encourage even more people to apply. And I think particularly for women, if they have families and if they're likely to have spouses who also have careers, I think this might be something that could overcome some reservations. But if this were an ongoing conversation, as opposed to something that we scramble to do just in the face of an imminent departure from the court and the need to recruit a new candidate, I think this might be something that could broaden the scope of the candidates. And as I've said, we do reach out to a broad range of organizations of lawyers and judges in Canada, but I think that particularly in finding people who are perhaps members of groups that are underrepresented, having an ongoing process of making the candidacy for the Supreme Court of Canada less daunting and more appealing, or certainly at least to create a more informed view, so that people do not come to the court and find that it really is difficult for them to serve, that their expectations are not what the reality is something that we need to think about. Because again, as I say, we have an outstanding court, and a court that in the context of world courts is unique and whose work is highly regarded. And I think we want to ensure that no person, no man or woman or member of any ethnic group or identification in Canada is ever discouraged from presenting themselves to be a candidate because of either a lack of confidence in what it might mean or a lack of knowledge. So I will stop here and be very happy to answer your questions, but I also want to appreciate Mr. Chairman and your committee for accommodating me being able to speak to you from Vancouver, because I sure needed my sleep last night. Thank you.
Thank you. Mr. Lametti?
Merci beaucoup, Madame Campbell.
Thank you very much, Ms. Campbell. So I will take the floor just for a few moments again to speak about the Honorable Nicolas Kassirer. He was born in 1960 and grew up in Montreal. He was admitted to the Quebec Bar in 1987 after having gotten a Bachelor of Arts with honors in economics and political science in 1981 at the University of Toronto. He also earned a degree in civil and common law at McGill in 1985. He then studied at the University of Paris, more specifically the Panthéon de la Sorbonne, where he obtained a degree in international public law in 1986.
Admission to the Barreau du Québec, Justice Kassirer clerked for the Honourable Jean Betts at the Supreme Court of Canada. He then served as professor at his and my alma mater, McGill University, from 1989 to 2009, and he was the Dean of the Faculty of Law at McGill from 2003 to 2009, when he was appointed to the Quebec Court of Appeal. Prior to his career at McGill, from 1996 to 2003, he was the director of the Quebec Research Centre for Private and Comparative Law, as well as a part-time instructor at Le Barreau du Québec and a guest professor at the Université de Paris. Le juge Kassirer.
Mr. Kassirer is perfectly bilingual, as you will be able to see this afternoon. He is equally articulate in the language of Molière and in the language of Shakespeare. He's a prolific author and has written or contributed to over 24 books. He has also written a number of legal publications, mainly having to do with the law of obligations, property law, family law, and wills and estates law, both regarding civil and common law. He's well known for his generosity and his collegiality. Judge Kassirer, as the Prime Minister said, has had an exceptional career as both a judge and professor. He has the esteem of his peers in Canada and around the world. There is no doubt that he would be a great asset to the Supreme Court of Canada.
I would like to conclude by reiterating my sincere thanks on behalf of the government to the Right Honourable Kim Campbell, to each member of the Advisory Committee, each person who was consulted, and each candidate who applied in this process. You have helped to ensure the strength of one of Canada's most treasured institutions, a Supreme Court that is respected and admired throughout the world. We are very grateful for your contribution. Je tiens aussi à remercier le commissaire à la
I also want to thank the Commissioner for Federal Judicial Affairs and their staff, who provided exceptional and professional administrative support throughout the process. Finally, I'd like to thank my parliamentary colleagues for having helped place the values of democracy, transparency, and accountability at the heart of this judicial appointment process. For at least 20 years, we have been looking for ways to get parliamentarians involved in the process of appointing Supreme Court justices. I believe that this is a crucial role, and the members of the 42nd Parliament can be proud of having moved things forward in terms of consultation and inclusion. Thanks to the constant support of the values of transparency, inclusion, and accountability, the selection process for Supreme Court justices will continue to strengthen public trust in this fundamental institution, as will the appointment of exceptional judges who reflect the diversity and the bilingual and bijuridical nature of our country. Thank you.
Thank you very much, Ms. Campbell. Thank you very much, Mr. Lametti. We tried very hard to get the lighting right for you throughout that entire presentation. Just for everybody's edification, the issue is a building-wide one, not for this room. Public Works is trying to resolve it, so please don't blame anyone here about the lighting issues. It is not the staff here doing that. So we're going to do 2 rounds of questions now. Et on va commencer avec le Parti conservateur. Et je vais demander à...
We will begin with the Conservative Party. Ms. Reid, please.
It's fine. Minister, thank you very much for being here. Ms. Campbell, thank you very much for all the work that you did for Canadians. I want to thank you on behalf of the Conservative Party of Canada for the 3 times in which you've chaired this committee. Minister Lametti, as you may have noted, Today in the Globe and Mail, and indeed many times this week, there have been discussions about SNC-Lavalin, and I'd like to know whether or not you've taken any steps to award a deferred prosecution agreement prior to the SNC-Lavalin appearing before court on September 20th of this year.
As you know, as I've said many times, both in the House of Commons and in other public fora, including in front of the press, I make no comment on anything with respect to that file. Anything that I can or might say might have an impact on ongoing litigation, and therefore I'm very careful in that regard. Thank you.
Thank you very much. Ms. Campbell, I wanted to ask about your process with respect to the advisory committee, and I'll tell you it's with the background of trying to understand of how to deal with a leak, because as you know, there was a leak that occurred in the last process that you chaired. When did you learn about the leak from the last process that you chaired?
Well, can I say that the leak was not from our process? After we present our short list to the Prime Minister, in partnership with the Minister of Justice and all of the other interlocutors, including, I think, critics, has an ongoing series of conversations. And one of the things that our advisory board is not mandated to do is to select candidates based on their philosophy. Now, if there were candidates who had particularly, views that might be considered less than, or more extreme in some way, or some, unconventional, we might certainly mention this. But it is up to the Prime Minister and his shortlist process to determine sort of compatibility or philosophical views. So there is a process that goes on after our committee. So there has never been a leak from our committee, nor I think would there be.
Sure. Very good to know. Minister Lametti just indicated, though, in his opening remarks that he took strict measures in dealing with this unacceptable disclosure by talking about making changes to the advisory committee mandate. If the advisory committee wasn't the source of the leak, why would Minister Lametti feel the need to talk to the advisory committee about the previous leak?
Well, I don't know, but I think he addressed that. But we have a very strict commitment to confidentiality, and including, not identifying who any of the candidates are. Mm-hmm. And I think there's never been any suggestion that any of the three members of the three committees have ever breached that confidentiality, nor would they.
The retired Justice of the Supreme Court of Canada, Louis Lubell, sat on your committee this time, and he gave commentary for the last time regarding the leak from the advisory process, where he said it was very serious because this process is a very delicate matter. Did he bring up any concerns about confidentiality during this process?
Not particularly, but because we were just obviously so devoted to it and so very, very careful to maintain that confidentiality.
Did you take any steps to determine and ensure that there is no leak of confidentiality from your advisory committee? I know you said there isn't none. I'm just wondering if you called anybody. Did you talk to the minister? Did you talk to PCO?
Well, I don't think it was necessary. We worked with the Commissioner of Judicial Affairs. Our documents, we worked with secure tablets, very carefully controlled. We always left our documents in the meeting room, and there was a clear commitment, and we signed an undertaking to maintain confidentiality. So I think the process was well established, and I just want to repeat that there has been no indication of any leak ever coming from a member of the committee.
So the Privacy Commissioner...
In fact, if anything, I think we were sort of tippy-toeing around often afraid, even among ourselves. And when we ate dinner together, we went someplace where people wouldn't even realize who we are and what we were doing.
That's tough to do for you, I would imagine, Ms. Campbell. The reason why I ask is because, of course, we are concerned with the leak and the way in which it happened. The Privacy Commissioner is concerned as well. The Privacy Commissioner is investigating the leak. They can't interview the Minister's office or the Prime Minister's office. I'm wondering if he had a conversation with you to understand the confidentiality around the advisory committee.
Well, no, because there's never been any suggestion that confidentiality has been breached. It's fair. I mean, I'm delighted that, this is a good job for your committee, is to obviously to be concerned about this. But I think that the nature of the leak, such as it was very clearly not from the committee process.
Thank you very much. Minister Lametti, you gave an interview to the Lawyers Daily in April, and in it you indicated that you were very confident that the leak did not come from the Department of Justice or from Prime Minister officials. Ms. Campbell, is now saying that it didn't come from her advisory committee. Where did the leak come from?
Well, I don't know. The Privacy Commissioner has stated that he's opened an investigation into the matter, and I'm not going to comment on his ongoing investigation. I will say that federal departments will cooperate fully with the Office of the Privacy Commissioner, and that I took steps in this current process, both in terms of limiting the number of people who had access to the process within my department, as well as segregating the server and doing everything securely that we needed to do to make sure that there was no breach of privacy from my department.
You did indicate. Oh, okay. We'll be back.
Thank you, Chair, and thank you to the Right Honourable Kim Campbell and to Minister Lametti for coming in today and for advising us of the process that took place. My questions, so we'll start with the Right Honourable Kim Campbell. Ms. Campbell, in 2017, when you appeared before the committee, you talked about some of the barriers that we faced with respect to appointing or having candidates that were women or of minorities or of Indigenous. And you outlined today that out of the 12 candidates, one was a woman, and there were no Indigenous. Were there any minorities that were also part of the candidates?
I don't think there were any who self-identified in that way, and that it is the self-identification.
Okay, and
the committee itself was concerned because we are, of course, limited to evaluating those who do apply.
Right. So there were, in 2016, there were 22 days to submit an application. And then in 2017, 63 days. And this time around, there were 30 days. And you talked about some of the processes in which you were reaching out to various organizations in Quebec. Do you think that time frame was sufficient to get the quality of candidates that we were looking for the Supreme Court?
Well, I would say that the quality of candidates was outstanding. And in fact, in all three processes, I think our committee members come away very encouraged by the quality of people who do apply. But, you know, one of the things that, because we must deal, people have to apply. So in the past, when, for example, we would get a nomination, somebody would write to us and say, I nominate so-and-so to be a candidate. I would immediately contact that person and say, your name has been forwarded to us as an outstanding candidate for the Supreme Court of Canada. You know, would you please review these materials, and if you are interested in being considered, I warmly encourage you to apply, which is the best we can do. And in many cases, you know, people are often shy about applying. You know, they feel, you know, am I being too arrogant? And so it's nice for them to be able to say, I was asked to apply. And it's something that maybe even the members of your committee might want to think about, is if you think that there are people that you know in the areas where the seats are vacant, that there would be nothing wrong with a member of parliament writing to say, I'd like to have so-and-so considered. And then what I or a subsequent chair might do would be to write to that person and say, your name has been forwarded. We don't say who forwarded it, as an outstanding candidate, and we warmly encourage you to apply. So I think the more ways that we can overcome people's reluctance to apply, the better. And it might well be something that members of your committee who are very engaged with this issue might want to address either as a committee or just as interested members of the committee to do.
Thank you. You spoke also in your remarks about diversity of opinion on the benches as well. And when we're talking specifically about provinces and the allotment from our constitution with respect to members from certain provinces on the benches, how does the provincial laws and policies, and in Quebec, I will refer to specifically Bill 21, and its long-term impacts would impact diversity of Supreme Court nominees that are being appointed on the bench? How does that impact the overall laws and the shaping of laws within Canada?
Well, that's a question I can't really answer. I don't, you have to follow the cases that go through, but I would say that on the basis of the candidates who were presented to us, we felt there was a strong commitment to serving not just Quebec, but to serve Canada, and consistent with the existing law of the Charter. But I think that these are issues that are certainly beyond the purview for me to answer.
Thank you. You also spoke about, as we talked about diversity. So what was the main or the primary objective? Was there any consideration that was given to what are the current members of the Supreme Court and collegiality to avoid things like groupthink, as you had mentioned? What were some of the considerations that were taken in choosing the right candidates that you shortlisted to ensure the diversity of opinion on the bench?
Well, in the three processes, we've had different mixes of candidates, including the different types of diversity. But we don't simply leave it at that. One of the issues that we explore when we are interviewing candidates is to draw them out on their experience and knowledge and understanding of the diversity of Canadian life. So if somebody might not be the member of a self-identified group that we think of broadly as diverse, but we want to know in your life, in your experience, in your work, how familiar are you with the challenges faced by the many communities in Canada who may be less represented in the administration of justice. So that kind of cultural and diversity literacy is for us a very important part of the outlook that we would like to find for candidates who would be playing such an important role on the final court of the land. So ideally, we will have more candidates who will represent these communities themselves, but that is not sufficient. I mean, we don't then just ignore it from somebody who is not from a diverse community. We really do want to know how much they understand of the reality of life that Canadians lead.
Merci beaucoup.
Thank you.
On va passer à Madame Moore.
Thank you very much. Ms. Moore, please. I'd like to come back to the short list submitted to the Prime Minister. In the media, what was said was that, to my understanding, the person chosen to be appointed was the first choice of the Quebec government, but there is no one who can confirm this information. Do you believe that it would be preferable, while preserving the confidentiality of the names of the other candidates, that individuals could confirm or deny whether it was their first choice? For example, whether the government of Quebec could confirm whether or not the candidate approved by the Prime Minister was their first choice, yours or that of the advisory committee, or not. If I understand correctly, these are recommendations. So even though it's very rare, the Prime Minister could choose someone who's not on the short list, or not choose the first choice that was put forward by the committee, and instead decide on the second or third choice. Would it be preferable to enable various stakeholders to confirm whether or not it was the first choice on the list, in order to see whether the non-partisan decision was respected? Well, that question is clearly for me. My opinion is no, I don't agree with that suggestion. According to the Supreme Court Act, the decision is ultimately up to the Prime Minister, the Governor and Council. I don't believe that it's a good idea to weaken the Prime Minister's capacity to make the best decision in his opinion, to consider the recommendations, but ultimately to make the decision that it is up to him to make. Moreover, if we disclose the recommendations, because I, for example, had made a recommendation based on the consultations held here in Ottawa, and if my Quebec counterpart had done the same thing, that would give an idea of who was on the short list, and that could ultimately weaken the confidentiality of the process. We want to protect the privacy of all candidates, who applied, especially those on the short list. I understand that it's very important to be cautious about what is or is not revealed, but would it not be helpful to at least know whether or not the Prime Minister respected the suggestions of the advisory committee? Or if ultimately he made his own choices, wouldn't that be more transparent? To have an idea whether the advisory board's decision was followed or not? The problem is that if I give a recommendation and that's not the ultimate choice, well, journalists such as those here in the room, you, my colleagues, will all ask me, who did you recommend? And it becomes too difficult at that point. It would become too difficult to protect the confidentiality of the process and to protect also the Prime Minister's capacity to make his own choices. But ultimately, that's already what's happening. Everyone is trying to figure out whether it was the first choice and ask questions. People are already trying to guess whether the primary recommendation was respected. Yes, but it's easier to close the door to these questions right from the beginning. Otherwise, it's a slippery slope. Ms. Campbell.
Just to clarify for the honourable member, the shortlist is not given with any order. In fact, we are, the names are given alphabetically. So the list of shortlist, we do not distinguish among them. Okay. And I have often said that our goal is to present the Prime Minister with a short list of candidates that will keep him up at night trying to figure out which one of these excellent candidates to select. So, but we do not, on the committee, we may have our personal favorites, but we do not make any indication of an order among the candidates that are presented on the short list.
Parfait. Juste au niveau de la langue, comment c'est évalué?
Perfect. Now, regarding language skills, how is that evaluated? Are there written tests, or is it a matter of self-identification regarding language capacities?
The Judicial Commissioner has developed a series of tests. So, for example, with the Anglophone candidates, they do a test, and I think the criteria that you have to be able to understand and respond to oral argument, to be able to read without translation, etc. And so, for the first two iterations, we actually lost some outstanding candidates who did not meet the standard of functional bilingualism. I must say, with the Quebec process, we didn't lose anybody because the quality of bilingualism is perhaps better established in the French, the Quebec French language legal profession. But there is a test, and I'm sure they'd be pleased to share it with you. But yes, it is a form test, and after candidates are interviewed, they must undergo this test as the final barrier to being considered for a shortlisted candidate.
Merci beaucoup, le temps est écoulé.
Thank you. Your time is up, Ms. Moore. Mr. Fraser.
Le Président, thank you very much, Ms. Campbell and Mr. Lametti, for being with us today. I want to thank you, Ms. Campbell. You've already done this twice now. This is the third time, and I want to sincerely thank you on behalf of all Canadians for the work that you and your committee members have done in all three different iterations of these committee processes. And I think, once again, it has led to an excellent nomination of Mr. Kasserer. So thank you for that work. I'd like to talk a little bit more about the timing of the application phase for people who want to be considered for the position. I know that after the first one that produced Justice Rowe, there was some discussion about the process being too short, that I think it was only 22 days, and then for Justice Martin's appointment in 2017, I think it was 63 days. You've talked a little bit about some recommendations that you think could be made in order to encourage more people to be ready to apply when the time comes. This time around, there were 30 days. Do you think that was sufficient? And are there any other recommendations you would like to give the committee so that we can perhaps recommend to the government going forward a process where there's enough time for these people who may wish to be considered to get their applications together?
Well, I think, you've put your finger on what is, the most challenging issue for us to face. And we would welcome recommendations of other approaches. I was not aware, I did not have a sense that there was anyone who did not apply as a result of the tightness of the application time. In the first time, as you may recall, the applications took place at the end of the summer. And that was very difficult because people were coming in from their summer cottages and trying to get hold of their assistants who could help them put together their dossiers on their cases, etc. I think this was a much more kind of mainstream, in the middle of the work year, people were around. I think it was a little easier to do. But I think at the end of the day, we're not going to be able to rule out early retirements from the court. And to assist the court in its business, you want to make sure that the court, which starts a new season, fully equipped, and that the people who are chosen to make, or the person who is chosen to make this important commitment, has the opportunity to organize his or her private life. So I think that's where the possibility of creating a greater preparedness among people who would be good candidates. And that would go even with members of the committee. If there are people that you think would be excellent candidates, even, to get there, get them aware, thinking about the process. Now, of course, it depends on where there's going to be retirements, but as we've seen, we can't predict the actuarial retirements that people sometimes retire early. So the answer to your question is we can do it better. I'm not aware that it was a major barrier.
Okay.
But I don't know that for sure, and I would hate to think that it was.
Okay, well, thank you very much for that. I know that this time around it was a bit of a unique process, given the fact that it was filling one of the Quebec seats, and so there was an advisory board for Quebec set up. And as you mentioned, given the fact that the Constitution recognizes, or the Supreme Court Act recognizes, that there is to be at least 3 seats from Quebec to recognize the uniqueness of the civil law jurisdiction. Were there any differences in the criteria, I guess, in the minds of the members of the committee in putting forward names for the Quebec seat? And were there any different questions in the questionnaire this time as opposed to the previous 2 that you did?
There were no differences in the questionnaire, and actually, as the process unfolded, it was very much like the others in terms of the kinds of things we wanted to know for people. Again, going back to the earlier questions about diversity, etc., we looked for the same kind of breadth in people, and I think the candidates were conscious of the fact that being selected for a Quebec seat brought with it a particular kind of responsibility in terms of the role of the civil law and Quebec values. But I think it was actually remarkably similar. And I have to say that the committee members were quite outstanding and very, and they made the point, yes, there's a particular set of criteria because of Quebec and its language and juridical uniqueness, but that this is a seat that will serve the whole of Canada. And so that breadth of knowledge and understanding was important.
Thank you. And Minister Lametti, if I can ask you, you touched on the qualifications of Mr. Casserer, and I agree with you that it's an excellent appointment. You talked about collegiality and temperament, and obviously in reviewing Mr. Casserer's application, it's clear that he has the legal mind and ability to do this job, and he's been widely regarded as an excellent choice. But also, his collegiality will be an asset that he'll bring to the bench. Can you talk a little bit about why that is so important for a justice of the Supreme Court of Canada, to have that collegiality and temperament that is appropriate in order to bring that along with the legal skill and mind that he has?
Right. Thank you for that question. Well, as Ms. Campbell pointed out, on a court you have a dynamic when cases are heard, and there's interaction amongst the judges, both in terms of the hearing as well as in the preparation prior to the hearing, and then in the decision-making phase afterwards, where there will be back and forth between and amongst judges in order to get better decisions. That doesn't mean unanimity. There will be dissenting and concurring judgments in which a judge may feel strongly about a point or about the decision's outcome generally, but you'll get better decisions. I had the good fortune of hearing Guido Calabresi speak 2 weeks ago about the American Supreme Court, and he said he clerked under the Warren Court, and he felt it was an outstanding court because specifically, the judges spoke to each other. They all brought different kinds of expertise to the court, and they were quite collegial. And he felt that the kinds of judgments that they came up with were better because of their collaboration and their collegiality. And we would hope for the same kind of thing here.
Thank you.
Thank you very much. On va passer maintenant au deuxième round des questions.
We will now move to the second round of questions. It'll be slightly different. 6 minutes for the Liberal Party, 6 for the Conservatives, 6 for the Liberal, 5 for the Conservatives, and 3 for the NDP. We'll start by Mr. Nassasi, please.
Thank you to Minister Lametti and Madam Campbell for once again making themselves available and explaining the intricate process which is involved in selecting Supreme Court justices. Now, the first question I had was for Ms. Campbell, and I'm returning to something that other members of this committee have touched on, and that is the issue of collegiality. You yourself kindly highlighted how significant that is. For me, the question remains, how do you quantify, or how do you try to measure whether a candidate does actually appear to be collegial? Is it a process of speaking to their peers, people that they have previously worked for, or, as you, I think, were attempting to highlight, is it reading their previous judgments or their jurisprudence and trying to get a sense that they come up with clear decisions?
Well, thank you for the question, and it is an important one. All of the candidates do have references that we consult, and that's one of the things that we ask about is, how collegial they are in working pattern. If I can give you an example from the very first iteration, the successful candidate, who is now Justice Malcolm Rowe, when we asked him his approach, because we asked him, how do you do this? What is your approach? And he made a very interesting comment, and I hope I'm not breaching confidentiality when I say this because he's already there. But he said, I can put a lot of water in my wine, and I have no pride of authorship. And I thought that was a very specific and powerful way of explaining his approach, that he wants to get someplace. And the important thing is, what is the fundamental idea that you want to see in the decision? How much water do you need to put in your wine? And perhaps allowing someone else to have the honor of writing the opinion, if it's the opinion that you are agreeable with, is good enough. And it was basically saying, I'm not an egomaniac, and I understand what's important and what isn't. And so when we ask candidates of their approach, they are often very revealing, and I hope Justice Rowe isn't cranky at me for any years that I've said that, but there he is already. But that's the kind of thing we look for. I mean, what has been your experience and how have you approached it? And for many of them, they have a lot of experience in this area, which is one of the reasons why judges who've already served on an appellate court, have a very clear understanding of what that question means.
Thank you very much for that. Now, another thing that you actually did touch on was you actually did say that you were concerned that only one candidate was a woman and there were no Indigenous candidates. And you touched on the fact that there is a need for ongoing consultations. Now, and this is in between what the advisory committee does. So who, in your opinion, does that obligation fall to reach out to people and familiarize themselves, familiarize various lawyers and jurists with what serving on the Supreme Court is like?
Well, I'm not actually sure whose responsibility is. I think it might be something that could be done in partnership with a number of different groups, law societies, bar associations, and that might be something that your committee could look at as well, what the ideal situation is. But one of the things that we have as a result of 9 new appointments since 2011, including Justice Cassirer, is that there are quite a few retired Supreme Court of Canada justices, lurking about, who might be available to give some honest views about what it really means to serve on that court. Some of them have 75, others who took early retirement. But I think
we lost it.
gathering, I think it was in Saskatoon, that talked about this, where in fact some of the people who attended were surprised at what some of the benefits and attractions of working at that level are, where they hadn't really thought about them. So I think it's not just to warn people about how hard the work is, but to talk honestly and openly about what it means to serve on Canada's highest court, and perhaps, sow the seed in some person of a desire to be considered for such a seat if the times align correctly.
Thank you very much for that. Now, if I could turn to Minister Lametti for my last question. As you know, Minister, the Senate Standing Committee on Official Languages recommended that changes be made to formalize the Official Languages Act to make sure that Supreme Court justices who are appointed are functionally bilingual. Is that something you would favor going forward?
Well, thank you for the question. First of all, we have done this in practice. We have enshrined a practice that puts such a high premium on functional bilingualism that it practically is a bar to being selected. We haven't done that formally. I'm not sure it's a good idea formally because there may be other needs of the court at some point. For example, to appoint an Indigenous person, where we may have to soften that requirement down the road. But I think we're at a nice compromise right now, where in effect there is a functional requirement, a functional bilingualism through the process, without having to worry about either the constitutionality of such a provision or amending an act formally.
Thank you.
Merci beaucoup, Monsieur Deltel.
Thank you very much, Mr. Deltel. Thank you very much, Mr. Chair. Colleagues, I'm very pleased to see you again. Prime Minister Campbell, greetings. I want to congratulate you on the quality of your French. And next time, if you're leaving Africa for Vancouver, maybe you can stop in Ottawa since it's on the way. First of all, I want to say that I'm very honored to be part of this committee today. As Section 10 of the Act says, the Minister needs to consult opposition parties, and it is with great honor and humility that I accepted the invitation of Lisa Raitt to be part of those consultations. But that's all I can say, because of course I can't give you the particulars of the who, where, what, or why, because all of that needs to remain confidential. Minister, in your opening remarks, you mentioned the importance of confidentiality and ensuring that there are no leaks of any nature. As you know, the last time there was a leak concerning a candidate to the Supreme Court on April 11th, this committee met, and the parliamentary group that you are part of refused to have the committee conduct a study. So how do you think that Canadians can trust in this process when the parliamentary group refused to investigate this leak? Well, first of all, thank you for your role in the consultation in this process. It was very valuable, and your comments are very important. So, yes, this is important. We took action on this process. We wanted to ensure that there wouldn't be leaks this time around, and we took steps to that effect. But we also have an officer of Parliament, the Privacy Commissioner, who investigates this type of thing. And so we are collaborating with them. As a government, we take leaks very seriously. And in this case, we ensured that they wouldn't happen again. But why did you refuse to have the Justice Committee look into it? It's our job as parliamentarians to look into incidents like that. Well, we have the Privacy Commissioner who has the authority to lead this investigation. And we believe that this is the right process. It's a nonpartisan process. And we believe that it will move forward appropriately. Mr. Lametti, a little over 6 years ago, you were appointed to this very important and prestigious role, the Minister of Justice and Attorney General of Canada. But certainly it hasn't been a quiet ride over the last 6 months. Among the events that occurred in the last 6 months, we had the SNC-Lavalin scandal, which really undermined Canadians' trust in the legal system. For 2 months, that incident monopolized people's attentions, unfortunately. And recently we learned that the architect of that scandal is back in the Prime Minister's entourage. So how do you feel that Mr. Butts' presence will create trust? Well, as I said earlier, I don't want to comment on that. Anything that has to do with I don't want to comment on anything that has to do with SNC-Lavalin because there is a case that is currently before the courts. And anything that I say could be interpreted or misinterpreted. So I don't want to comment. But the reality is that you need not only justice, but also the perception of justice. And when you see this person who played a key role in the SNC-Lavalin scandal, and we see that he is going to be involved in the Prime Minister's election campaign, as Minister of Justice, how can you remain neutral and refrain from commenting? Well, unfortunately, my answer is still the same. I will not be commenting for the reasons that I just laid out. That's very unfortunate for Canadians, Minister. Well, as Minister of Justice and Attorney General of Canada, I need to respect the legal system, and I need to be careful not to influence any cases that are before the courts. But that's exactly what was at the heart of the SNC-Lavalin scandal, political interference in the legal system. Well, with all due respect, this is not a political issue. This is a case that is before the courts. And we can't have an impact on cases that are before the court. So it's very important for me in my role to protect the legal system. Unfortunately, that wasn't the case during the SNC-Lavalin scandal. I did what I had to do as Minister of Justice and Attorney General to protect the system and to respect the role of the courts. Do you feel that the legal system emerged from that scandal better? Well, I'm very proud of our legal system. We have a number of institutions that did what they needed to do in that specific case. In this case, as I said, I'm very proud of the system and the way that it worked. Unfortunately, the time has expired.
I'm here today to talk about the nomination of the Supreme Court Justice and this process that led up to that. So I've been very flexible so far as Chair in permitting questions, and the Minister has been very kind in answering those questions, but that is what we were here to talk about. We are now, Ms. Vandenbeld and Ms. Fortier are sharing the next time.
Thank you very much, Mr. Chair, Minister Lametti. My question actually follows up, Ms. Campbell, on something you said in an earlier response about looking at diversity and cultural literacy. I also share the disappointment that only one of the 12 candidates who put themselves forward was a woman. And I noticed that in addition to professional qualifications, legal skills, the criteria also include a number of individual qualifications like discretion, judgment, integrity, respect, and ability to empathize. So with regard to gender equality, with regard to sensitivity on gender issues, if you could elaborate a little bit about how your committee was able to make sure when you were looking at the different candidates, what kind of criteria and what kind of questions did you ask regarding the various candidates' gender sensitivity?
Well, I think this was in the broader questions of their own experience with respect to diversity, and we would have a conversation and an ongoing conversation, but there is no question that there were opportunities for the candidates to discuss this in their own questionnaires. Their references were asked about this, and I think this was it was kind of a fundamental value this sensitivity to gender issues and issues beyond, because these are all issues that come before the court. So I'm sorry, I can't probably, if I went back and looked at the question more specifically, I can give you a more specific answer. But I think there was certainly a consensus. And incidentally, I think half of our committee members were women, and very distinguished women. So there was a strong kind of institutional support for recognizing openness to the equality and equal treatment of women under the law as part of our whole mandate.
No, thank you very much. I'll turn the time over to Ms. Fortier.
Merci, merci beaucoup, Madame.
Thank you very much, Ms. Campbell, Mr. Lametti. Thank you for being here today and for talking about the process with the committee. I want to come back to this issue of official languages. It's something that I care about, and I think that Canadians care about too. We want to have a Supreme Court that represents both official languages. We heard a little bit about this, but in terms of the selection process, could you tell us the degree of importance of official languages and why this candidate meets those requirements?
Are you asking this
Sure.
for me?
Oui,
I'm
s'il vous
happy to-
plaît, Madame Campbell. Oui.
Yes. Well, I think not only does this candidate meet it, in fact, the Francophones on the committee spoke about the recherche quality of his French, that he speaks beautiful French. And I think you would find that Justice Kassir, he feels his work in the civil law and in French really kind of defines him and his connection to Quebec. It was actually quite remarkable to see that he is a man who loves the language and loves to use it in its most refined and excellent and precise way. So that is actually a kind of the whipped cream and cherry on the top of his qualifications. That is not just as he is, profoundly bilingual and profoundly competent in both languages, but that he relishes the use of both languages, particularly French. And I think he speaks French as his preferred language of expression is French. In a way that really elevates its importance. And I think the notion of the official language, I mean, this has been a criterion that has been fundamental to all three of the processes. And there were some candidates who had very fine qualities who did not pass the functional bilingualism test and therefore were not considered to go on a short list. So it is a principle that has been adhered to over the last three searches quite fastidiously. And it's not just that people argue in French. I think the idea is to make it possible for judges to communicate with one another and to have that capacity to reason together in either language that we think, or that is the underlying principle behind functional bilingualism.
Monsieur Lametti, est-ce que vous voulez commenter sur ma...
Mr. Lametti, do you want to add anything? I'll just agree with what Ms. Campbell said. The quality of his French is really exceptional. And that's something that's very important in the process. I think that we really met that criterion in a very clear way. And also, he also met the requirements for English. Oh, yes. Judge Kassir is an Anglophone, but he speaks French perfectly. Thank you for clarifying that.
Merci beaucoup. Ms. Reid?
Thank you very much, Mr. Chair. Minister Lametti, I'm going to go back to, if I may. Oh, before I do that, Ms. Campbell, I wanted to ask, in the terms of reference, there's a provision in there that says if there is a declared person of interest, or if the member of the advisory committee has a business or a personal relationship with somebody that's been nominated, then they recuse themselves from the discussion. Did that happen in your process this time?
Yes, it did. One of our committee members had served in a firm. I don't want to go into too much detail, but someone, and recused himself from the conversations about that person.
Would that be something you'll publish in your report that follows on?
I think that's perfectly appropriate to mention. And again, I want to go back that the committee members were very conscious of their responsibility and their desire to conduct themselves in a way that was beyond reproach.
No, and I appreciate that they recuse themselves and they follow the rule of law on that. Minister Lametti, now let's be very precise here because you're a lawyer, I'm a lawyer, and precision is important when it comes to this. Ms. Campbell has indicated that there is no way that the advisory committee was the source of the leak of the information regarding the former proposed candidate, Mr. Justice Joyal. You have indicated to the media that you're convinced that it did not come out of the Prime Minister's office or out of your office. The Privacy Commissioner is conducting an investigation that you said that people are cooperating with. But is it not the truth, Minister, that the reality is that the Prime Minister, yourself, or any member of your staff or his staff are exempt from the Privacy Commissioner's powers and will not be part of this investigation?
I have said from the outset that my department will cooperate, and that I am, as I said, I'm confident that the leak did not come from the very few people in my ministry.
Minister, your department will cooperate because the Privacy Commissioner has the power to summon anybody in that department. However, the Privacy Commissioner does not have the power to summon yourself, the Prime Minister, or anybody who works on the political side of your department or the Prime Minister's office. Are you telling me that they are going to voluntarily speak to the Privacy Commissioner in order to make this a fulsome investigation?
I'm going to let the Privacy Commissioner do his work.
Well, he is working within his own mandate, but what I'm pointing out is that contrary to what you're hoping to say here, that everything is being covered, the reality is there are some significant witnesses who are not being investigated on this, and we are left to rely upon the word of you, relying upon the word of the Prime Minister. I think that's a fair statement.
I'm going to not comment on anything that's an ongoing investigation by the Privacy Commissioner, other than to say, as I've already said, that there will be cooperation.
So, Minister Lametti, the advisory committee chair has indicated that there was no leak from her committee. You have indicated that it did not happen from the Prime Minister's office, that it did not happen from the Department of Justice, and it did not happen from your office either. However, you did say that you could ask another department in government to investigate, but again, the Prime Minister has been quite clear that he doesn't feel that it's come from PMO, and I believe him. Have you investigated beyond the Prime Minister's feelings?
I'm letting the Privacy Commissioner conduct his investigation, as I've stated publicly on a number of occasions, as you rightfully pointed out.
Minister, you actually indicated to a publication that you felt that the leak came from people who had been consulted after the advisory committee through your own consultations. Can you provide a list of the people that were consulted post the advisory committee in the last round of process so we can get to the bottom of where the leak really is coming from?
I was not the minister at the time, so I wasn't privy to all of those consultations.
So you're not going to ask the department to provide a list of those who were consulted in order to help us figure out who leaked the personal information of Mr. Justice Joyal.
Once again, those conversations would come under the purview of the Privacy Commissioner, and therefore I'm going to let the Privacy Commissioner do his work. He's an officer of Parliament. We have respect for officers of Parliament. Going to let him do his work.
Mr. Lametti, you're splitting the hair, and it's not fair because you know the difference between what a member of your political staff is subject to and what your department is subject to. And Mr. Chair, that given the comments from the Right Honourable Kim Campbell that the leak of information related to Justice Glenn Joyal is an important issue for this committee to study, the Justice Committee immediately began to study this matter. I'm moving that motion.
So there was a motion moved. Do you have it in writing, Ms. Wright?
I have it in scribble.
You have it in scribble. Okay. So what we will do is I am going to give the floor to Ms. Moore for her round of questions, and then I will come back to telling you whether the motion is receivable or not after I've consulted with the clerks.
Thank you.
Ms. Moore?
Thank you very much. Currently in Quebec, there are two big issues in terms of justice. First of all, there's been a lot of thought about the reform of family law. For example, common law partners, rights and obligations, the role of grandparents, the issue of reproductive technologies and the impact that that has on family law and on estate. And then there's also the issue of sexual assaults, sexual offenses, how they're processed and dealt with in the justice system, and particularly with cases where, not many of them end up in court. So in terms of those two big issues, were you looking for candidates that had particular expertise in either of those areas or particular knowledge? Well, obviously, the knowledge of civil law is a criterion. So much of what you've just described does fall under civil law. And then part of it is also criminal law, which is federal. And so this is something that was taken into consideration by the committee. Perfect. As far as you know, does Judge Kassir have particular knowledge? I mean, you mentioned some family law publications. Does he have any particular knowledge in family law, for example, and particularly the reforms that are coming in Quebec? I would say that yes, I know that he has published papers in that area. He has taught family law for many years, and particularly property law. He also led courses in criminal law throughout his career. Ms. Campbell may add something to this as well, but certainly looking at his record, it's clear that he has exceptional knowledge in that area. Thank you. And in terms of sexual offenses, that partly falls under criminal law, but sometimes those cases do end up before civil courts. There are a number of cases in Quebec that fall into that category. Yes, I would need to refer to the file, but I believe that he also has experience as a judge since 2009, where he presided over a number of cases like that. So he has written some rulings. And Ms. Campbell, did you want to add anything?
No, simply to say that as the author of the revision of the rape shield provisions in the criminal code back in the early 1990s, it's been a source of great frustration to me that many of those principles do not seem to be applied often in the courts, and that's a challenge that I think you as legislators are going to continue to be addressing aside from the culture of the courts. But I think that our view of Justice Kassir was that he was very knowledgeable and very, I think, equipped to uphold those principles, which are in fact based on legislation.
Parfait.
So before I get to the motion from Ms. Raitt, I want to thank the Right Honourable Kim Campbell for her continued service to this country and the incredible work that she continues to do in this regard and in many other regards. Thank you so much on behalf of the committee and all Canadians. I know all members of all parties would join with me in that. And thank you so much to Mr. Lametti for being here today and giving us his very frank answers to questions. I'm going to, so I will excuse the witnesses because I think that they don't need to sit there the entire time as we go through the motion. But you're welcome to stay, of course, to the extent you'd like. Do you want? So I'm going to suspend for a second to let the minister leave and to let Ms. Campbell leave, and then I'll come back to the motion. So the meeting suspended for a brief moment, and we'll. I'm now resuming the meeting. I wanted to look at all of the issues surrounding the motion. There are some small issues in terms of rewriting that I think Ms. Reid is comfortable with providing a slightly revised wording, so I'm not even going to get into that issue. The issue that I was trying to look at was that we had met in April, on April 11th, and Mr. Cooper had presented the following motion: that the committee sit additional hours to study the leak of information surrounding the Supreme Court of Canada's selection process, particularly as it pertains to the leak of information surrounding the Chief Justice of the Manitoba Court of Queen's Bench, and that the committee report its findings to the House no later than Friday, May 31st, 2019. And I had a concern that this was an issue that the committee had already visited and defeated, which would make it not receivable. However, I always, in the last 3.5 years, have erred in favor of receivability of motions, and I can say that the way that the motion was worded, it was based on something that was said by Ms. Campbell today. So I think in principle, it's better to allow the motion to come forward and have a discussion on it, and the committee can treat it how it wishes. But I'd ask Ms. Reid to simply reread the motion as the clerk present. Oh, maybe I'll reread the motion as the clerk
Yes, I
had
will.
redrafted it.
Thank you. Put my glasses on. The motion as it reads, Mr. Chair, is that the committee immediately begin a study into the leak of information related to the possible appointment of Justice Glenn Joyal.
Thank you very much. So I'll give the floor to whoever from
I will, yeah,
Ms.
thank
Reid.
you. Thank you very much, Mr. Chair. Thank you very much for ruling this admissible. Through the questioning today, something has become quite apparent to me, and it has been confirmed for me as well in the discussion I had with Ms. Campbell that this is truly an important issue for us to study. The chair of the advisory committee on the Supreme Court of Canada nomination process has indicated that this would be something that she thinks MPs would be interested in getting to the bottom of, and I agree with her, and I appreciate that piece of advice. I also am concerned that there seems to be a miscommunication, deliberate or not deliberate, with respect to what is actually being investigated now and who is being investigated. And I understand that part of the, defense to saying no to a Justice Committee inquiry was because the Privacy Commissioner was doing his job. As you may have noticed today, I brought up the fact that Section 50 of the Privacy Act exempts any political staff or ministers or prime ministers from an investigation. So simply put, the Prime Minister will not be interviewed by the Privacy Commissioner. Minister Lametti will not be interviewed by the Privacy Commissioner. The cabinet ministers who were consulted as part of the previous process will not be interviewed by the Privacy Commissioner. Elder Marquez will not be interviewed by the Privacy Commissioner. Matthew Bouchard will not be interviewed by the Privacy Commissioner, and neither will Ben Chin be interviewed by the Privacy Commissioner. And the reason why I'm concerned is that in response to my questions, the minister was very careful when I asked whether or not his political staff were going to be interviewed, responded by saying his department will cooperate. That is, I believe, a deliberate attempt to split a hair. And I, as a former minister, I don't appreciate it because I don't think it's being fair to Canadians to allow them to understand exactly what is being investigated now. As a result, I'm proposing this motion so that no gap will be present in any investigation regarding this incredibly egregious leak of information, personal information of Mr. Justice Glenn Joyal to the press, with the purpose, quite frankly, of delegitimizing whether or not Jody Wilson-Raybould was in favor of the charter, because that's where it all comes back to. So as a result, I look forward to the comments from my colleagues around the table regarding the matter. I would point out one last thing with respect to what Minister Lametti testified today. When I put it to Ms. Campbell whether or not she discussed the matter of the leak with Minister Lametti, she indicated that she did not discuss the matter of the leak with Minister Lametti as he went forward in the new process. That, to me as well, is of concern, and I think at the very least Minister Lametti should return to answer questions on the topic, and as I indicated before, anybody else who was involved in it. This committee has the ability to call everybody. The Privacy Commissioner is barred by statute from calling the key people who politically had the information of a discussion between the former Minister of Justice, Jody Wilson-Raybould, and the Prime Minister of Canada. And we're not going to be getting to the bottom of anything unless we have those people come forward and tell us what happened. So thank you.
Thank you. Anyone on this side wish to intervene? Not. Est-ce qu'il y a-t-il des autres intervenants sur ce?
Would anyone else like to speak on this? Otherwise, we'll move on to the vote.
Is recorded? Yeah. So I'm going to turn to the clerk then, please.
Madame Fortier?
No.
Monsieur Essassi? No. Monsieur Fraser?
No.
Madame Khalid?
No.
Ms. Vanderbilt? Mr. Barrett?
Yes.
Monsieur Deltel?
Oui.
Miss Raitt?
Yes.
Madame Moore?
Yeah. La proposition est défaite 5.
Accordingly, the motion is defeated 5-4. Other business? Any other observations?
Thank you for being here with us today, and I imagine this is perhaps our last meeting before the election, so I wish everybody a very nice summer and a good campaign. Meeting adjourned.